FM. It's 9 minutes past 10 o'clock this Wednesday morning. It's time for Probono Chambers. My name is Ruth Usman, and I am being joined by Barrister Adamson and Barrister Adana this morning. I choose to go by that and first name. Good morning to you, gentlemen of the
Good morning, Ruth.
All right, so nice to have you both, all having shades of black here and there. Did we have some sessions this morning? Court sessions. Okay.
I was actually surprised when I saw you this.
You see? So I was not wrong. Okay.
Yeah.
So you're just doing your law thing. It's all good.
Like
So,
minds.
yeah, I hear like minds. So I'm so on my own, yeah? All right, so it's time for us to talk on Pro Bono Chambers, where we talk about anything and everything legal, and we also provide you with free legal advice right here on this program. But that will be when we open up the phone lines. In the meantime, we'll be focusing on employment compensation in Nigeria. Employment compensation in Nigeria. When your employer decides to compensate you for things like personal injury. We talked about personal injury yesterday. I'm a good student, you know.
Very good students.
All right, but then we will focus in this aspect. Are military officers covered by this legislation? So, let me allow you.
All right. Thank you very much, Ruth. Compensation, as it is the one of the most important part of employment because it deals and focuses most importantly on the entitlements and benefits accrued to an employee who is injured at the course of his employment. Sometimes his dependents can also make applications or seek for this compensation to be paid to the person, especially where debt is involved. However, the Employees Compensation Act 2010 is a piece of legislation that oversees this particular issue as it concerns the employees in Nigeria. It focuses on the open and fairness of this practice and ensures that there's an adequate compensation for any employee who is injured, any employee who had experienced any form of disability or death as a result of his employment or as a result of occupational accidents or at the point, at the cost of him working for someone else. However, the law, the Employees Compensation Act, has been established to provide this system, to enable both dependents to benefit of the compensation, especially where the employee is not in view to make such a thing happen or to make such a application or to make such effort to get compensation at the point where he's injured. The law is applicable to all employees and employers in Nigeria, the Federal Republic of Nigeria, especially those in public and private service. It is not applicable to persons who have been employed as military officers, that's in the armed forces capacity. It's only concerned to persons who have been employed in civilian capacity here in Nigeria.
Okay, Mr. Adamson, you want to add on that?
Well, that is the background. But basically, when you talk about before the advent of the Employee Compensation Act, it is been a common law that principally governed before the repealed Act. Now, then, what you do, Workers' Compensation Act,
Yes.
which has been repealed.
Yeah.
Now, before then, for you to be entitled to compensation as an employee, it's like a liability that you have to prove specifically against the employer. What do I mean by this? As an employee, if you want to claim compensation against your employer, for instance, having sustained injury in the course of your employment, or a death occurring in the course of employment, you have to situate that situation within your workforce. That, oh, this thing happened to me when I was working for you. And the Employee Compensation Act has come to play to redress some of these lapses in the whole system by saying, oh, what do you mean by in the course of employment? Those are the issues that the Act addresses. Now, if, for instance, you are working and perhaps you sustain injury or death occurs or you contracted a disease, maybe as a sort of industrial pollution or problem right there. Now, this Act is saying, no, you don't need to prove it. You don't need to prove that this, as long as you can establish that you are working with that. Now, the Act goes further to say that, for instance, if you sustain this injury, maybe when you are going home, incidentally have a matter of that nature too.
Going home from work.
Yeah, somebody close from work. On his way home, he had an accident. So the employer will say, no, this thing did not happen in the course of employment. But it was proven that that action is situated within the provision of the Act. That what the Act says is, whatever happens between your workplace, when you close, to when you get home, in as much as you are going home from your work, it is covered. Again, if, for instance, somebody, your emolument is paid in the bank, your usual place of collecting your salary is in the bank. In the course of going to collect your salary, something happens. It is still within your workplace. Or you are going to a casino and something happened to you. You know, those are the things that the innovations introduced by.
Does it also include it from home to work?
From
home to work.
Oh, yes,
because when you set out, you had set out for work.
You have a regulated time. For instance, you resume 8 o'clock.
Yeah.
And maybe you left your home around 7. And you are coming straight to the office. And along the line, something happened. It is still within your working time. So those are the new areas that the new law has introduced, which is fantastic, and which is at variance with the former position. Now, that's not all. Now, when you talk about Employee Compensation Act 2010, it is unlike before, when you say, oh, I'm a private employer, it does not concern me. No. So it covers both public and private employers, to the exclusion of those in armed forces.
Okay.
So if you are employed as a military personnel, a police officer, or whatever, in that category, paramilitary, they have their own regulated ways, their own method of compensation, which is not covered by the Employee Compensation Act.
Interesting.
That's a variance. Then, again, the employer has his own responsibility under the Act. The employer has his own responsibility. What do you do? There is a NSITF, Nigerian Social Insurance Trust Fund. Now you have management board that manages the provisions of the Act. Now, every employer has a responsibility of making 1% contribution of the emolument, employees' emoluments, monthly, 1% of it monthly, into a particular account, which is being managed by NSITF. So it is then when you have issue, I know we still get there. When you have issue, there are provisions, there are guidelines. If an accident occurs, you have within 14 days to notify your employer. But if death occurs, then it must be reported immediately. Now, if it's an injury, you report within 14 days. Then, upon the receipt of your complaint, your employer has 7 days to report to NSITF, that's Nigerian Social Insurance Trust Fund, Management Board. Is it complex?
Oh, no, it's okay. I'm just wondering why the variance. I mean, death and injury.
They are not the same.
Why?
For example, somebody who dies will not have the capacity to report himself. So is it the dependent that will report?
And it has to be that day. So why?
Not immediately daddy. I said immediately.
Immediately.
Immediately
Okay,
does
yeah.
not mean daddy.
Okay.
But you see,
And so
maybe-
immediately, immediately sounds to me more urgent than the 14 days.
that is the language. That's the language of the heart.
Okay.
Immediately. And now when you're interpreting immediately, it will mean it is when practicable.
Okay.
When practicable. Now, somebody who has lost a relation, or maybe a husband or wife, like, you don't expect that person who is sorrowful, who is money.
To start, that's my thoughts.
So it's not. So when we talk about immediately, we are talking about a practicable time.
Okay.
Maybe a day or 2 days after. So.
Okay, in addition to that, the art has also provided that if an employer does not contact the NSITF, that's the Nigerian Social Insurance Trust Fund Management Board, to give them the details of the employee who has been injured or who has experienced any form of disability or accidents in the course of employment within 7 days, it will constitute an offense under the Act. That's an addition to what Mr. Adamson has said. Another addition is that, whatever complaints, whatever claims you have to make, either for death or for injury or for any form of disability at the cause of employment, it should be done within 1 year. So even if you don't do it within the stipulated period of 14 days, it should just be done within 1 year, seeking for the compensation. So, we're talking about persons who are bereaved and they are mourning. Of course, even if they need time to, bury their person and, cry and, deal with the situation, they should try and make contacts with the employer within a period of 1 year.
Now remember, the 1 year provisions is akin to the statute of limitation. Now, the implication is when you don't take action within 1 year, your action will be statute bar. In other words, you can't lay claim to that your claim. So it is statute bar. So it is better, well, whatever you want to do must be done within 1 year. That's the implication of that provision.
Okay.
Otherwise, you won't have a cause of action.
So it means even for the injury that you have 14 days, if it exceeds that, it's not necessarily a problem.
It's still actionable. It's still actionable.
Particularly, we can profile the reasons why you could not make that complaint within 14 days. But all we're saying is, any action you want to take, maybe you want to receive an action, you want to lay your complaint to NSTIF board, that must be done within 1 year.
Okay.
There are procedures. I think we'll see get there. There are procedures of complaint when you want to take action in cause when you incur any injury or death occurs.
Yeah, so let's talk about it. What's the procedure? How do you go about it?
How you go about it, first is to notify the employer. And in notification of the employer, you have to make provisions of the details of the employee, which should consist of his name, his place of employment, whatever it is related to his cause of employment.
It's not going to be verbal.
It doesn't have to be in
verbal, writing.
It should be in writing. It's an application you have to write.
Okay.
So you have to first notify them and then put it in writing with all of these details and whatever documents that would show evidence that such person was working with the employer. And then you have to also do that within 14 days like we earlier said. So that's just the process. And then you do a follow-up because the employer needs to notify the Nigerian Social Insurance Trust Fund Management Board on this, and then providing the circumstances of the accident which has occurred, and then the nature of accident that has occurred has to also be provided.
Okay, we'll go on a quick commercial break and we'll return and continue with the conversation. Do stay with us on Human Rights Radio 101.1 FM.
Your right, my right, our right. Everybody's right is protected. Human Rights Radio 101.1, redefining broadcasting. Residents of the Federal Capital Territory are reminded of the need to be law-abiding, especially in areas of road use and illegal squatting. Please note that the Ministerial Joint Task Force is mandated to ensure that the existing ban on the use of unpainted vehicles as commercial taxis is enforced, and that of minibuses and coasters alike, to ensure that a complete ban on the use of motorcycles as means of transportation within the capital city center is enforced, to ensure the restriction of tricycles, keke to estates and designated areas within and around the capital city center, to ensure the eradication of the activities of commercial sex workers in the city, to ensure the eradication of other public nuisance such as drug trafficking, peddling, and removal of all illegal shanties and squatters, to rid the city of illegal motor parks and bus stops within the capital city. Let us together build an FCT of our dreams. Those arrested will be prosecuted. Be law-abiding.
Farmers plus header people. E good make we hear wetin the minister for FCT, Malam Muhammad Musa Bello talk o. Him tell all the people that where they carry cow waka up and down, make them for go settle for where government give them for grazing for inside FCT. This go help reduce them suffer head to waka up and down. E go dey easy for government to fit support them. Make we say no to kili bonu plus scatter. The society need headers plus farmers so make food for them for we obodo for all of us to chop. Make headers no enter people farmland. Farmers report anybody when no one hear word. Make it for hear way. Make anybody no put the law for them handle. Make we come together to build peace. Now Federal Capital Territory Administration they bring from this message.
Hukumar kula da babban birnin tarayya Abuja na jawo hankalin Fulani makiyaya cewa ya zama wajibi da su bi kiran ministan babban birnin tarayya Malam Muhammadu Musa Bello da su rungumi zama a wuraren da aka keɓe musu don kiwo a yankin domin rage wahalhalun da ke tattare da yadda suke yin sana'arsu a yankin. Zama a wuraren da aka keɓe don kiwo zai kawo musu sauki musamman ta fannin yawan tashi da barin matsuguni domin cirani, kuma zai baiwa gwamnati daman samun su cikin sauki don taimaka musu da ababen da suke bukata kamar al'amuran da suka shafi likitocin da ke kula da dabbobi. Ilahirin al'umma na bukatar makiyaya da manoma domin samun wadatan kayan abinci. Makiyaya a kula da hanyoyin da aka kayyade domin ku a babban birnin tarayya, a kauce mashiga gonaki. Manoma kuma a bada rahoton duk wanda ya keta wannan dokan. Kar wani ko wasu al'umma su dauki doka a hannunsu. Mu haɗa hannu domin samar da wanzuwar zaman lafiya a tsakaninmu. Wannan sako ne daga hukumar kula da babban birnin tarayya Abuja wato FCTA.
Agwo anakwo kan ba filo ele FCT ele na Abuja ege owe minister o be dafe ege ye wala ba bwa ga hwe hwa hwe hwi hwa nakwo na ba na tabe je gugbo ba kunsun na hwani hwa japma ege na nakwo zokwe na ya hwe ele FCT na Abuja nu adabe je anyawu kunsun na hwani hukuma ele FCT ele na Abuja ba ya hwani lo ba ye anakwo kan lo mba na hedo na hwani bodo na anakwo kan hwe jina ba hwe aku ye hukuma aku sasaji akukọ dada agwo anakwo kan hwe to lo ahwanu zokwo ahwani hwetelo agozoko na gaba na baba kamba na kochon hwebe ya na bwado na ba ya mwaiki ago na hwani hwesase na je lafiya LFCT na Abuja bade kwen kwakun ege LFCT minister Malam Muhammad Musa Bello.
bandaɓe waynaɓe fulɓe ɗum nangi noto en noddago ministajo lamorde lesdi ndi Mouhamadou Moussa Bello dow waynaɓe fulɓe nattito durduɗe ɓe nokkana to lamorde lesdi ndi nde Abuja hakkude mabɓe remoɓe ɗum heɓa jonde jaam e ɗawta risku takanas to ɓe keeɓi ɓe joɗake ndebi guere nattuki nde ladde wallira kadi gomnati heɓa waɗanaɓe ko hani annaɓe to jaamo mabɓe e nanta dabbaji mabɓe bandaɓe to en jaaɓu tawe en kaɓa hakkude meɗen remoɓe ɓe nde fina Allah fo leñol lesdi ndi en giɗi gaynako en giɗi demowo gin jonde jaam e jahargal yeeso risku mayri bandaɓe waynaɓe jaaɓe joɗo en to darduɗe ɗe e lamorde lesdi ndi Abuja nokkani e gam jahargal yeeso hakkunde meɗen e remoɓe to komo fu jaɓa nangire aybe de handaki en fu meɗen en kawtu koɓe gam rastinki resku lamorde lesdi ndi Abuja lilal ɗon gal ardungal lamorde lesdi ndi Abuja lildani en.
Kedi ịchọ? Ọ bụ ife eji esi nri, ọ bụ akwa na akpụkpọ ụkwụ, ka ọ bụ akpa ụmụ gị ji eje akwụkwọ na ife iji achọ mma? Gbalubịa Halibis Mall, isi ụlọ ngwaahịa anyị dị na plus 660 Cadastral Zone B1, Franca Afegua Crescent Zone E, Apo Legislative Quarters, Gudu District, Abuja.
Anyị nwekwara ụlọ ngwaahịa anyị ọzọ na number 1 Medical Center Road, Maraba, Abuja.
Nke ikpeazụ bụ na number 21 Sariki Meizabo Road, opposite FMC, Kefi, Nasarawa State.
Gwa anyị na ekwentị.
Akara ekwentị ị ga-eji nweta anyị bụ 081
ka mkpọkwa ya n'olu ndị iti
08159510000.
Halibis Mall nwere ife niile ị chọrọ n'ofu ebe.
Ngwaahịa anyị adịrọ ọnụ ma dịrị mma nke ukwuu.
Gbalubịa na Halibis Mall. Nnọọ.
Your right, my right, our right. Everybody's right is protected. Human Rights Radio 101.1, redefining broadcasting.
Join our diverse team of legal experts as we provide education and guidance to you, our listeners, on a broad array of issues raised by the modern legal landscape, absolutely free on Pro Bono Chambers, airing on Human Rights Radio 101.1 FM, redefining broadcasting.
Human Rights Radio.
Welcome right back. We're here and it's 10:30. Pro Bono Chambers continues. Today we have been talking about employment compensation in Nigeria with focus on the military, whether or not the military officers are covered by this legislation. Okay, so far we've not really done much on answering that particular question, but then you've made it very clear. Cases or instances whereby one could actually seek for employment compensation in case of anything going wrong in the course of carrying out your duties at work. Now, are military officers covered by this legislation? Whose question is that now?
It's our question.
Yes, I've stated that earlier, that the armed forces members are not covered by the provisions of.
There's like uniform men, you said earlier, yeah?
Yes.
That every uniform.
Yes.
So why is that?
They have their own special ways of compensation. Mind you, they've signed off their life to the Federal Republic of Nigeria. They are special children. They are special species of persons who have their own special ways of being compensated. So it's different from this one. This is just a general provision for maybe civil servants and other employees of private firms, private organizations, individuals. So in the light of the provisions of the Employee Compensation Act of 2010, the armed forces members are not included. Notwithstanding that, we are not saying that they don't have their own rights to compensation, but we are saying that their own methodology is within their own areas or other laws are enacted for that purpose. You know, we have other laws that govern them. That is not the subject of discussion today. So we are not going to that. All we are saying is that as far as this law is concerned, they are not covered. Okay. Now, if a military person sustains injury or dies in the course of service, the special law provides for their own method of compensation. Okay? Or, again, all this we are talking about here does not prevent anybody from going to the regular court of law. However, for you to have access to the court of law, regular court of law, you must have exhausted the remedial method of remedy. That is, I'm talking about the local rules made in the organization. You have to exhaust it before you can. It is when they fail that you cannot proceed to a regular court of law.
Will the regular court of law, can it supersede? Is it higher than whatever is obtainable in their different organizations?
Oh, very, very high. That is why we have hierarchies of seeking remedies.
Okay.
For instance, even in the regular court, we have hierarchy. Now, if you are not satisfied with the decision delivered by High Court of a state, you proceed to the Court of Appeal. And if you are not satisfied with the decision of the Court of Appeal, the Supreme Court is there, which is the final, in the sense of finality. Once the Supreme Court gives the decision, except you appeal to God Almighty. So that is how it is obtainable everywhere.
Okay.
So if you exhaust the remedy provides by the enabling law, and you are not satisfied, then you proceed to the regular court. So it's as similar as, and that is similar.
That's to say, if you had a case and it was judged and everything, in the other provision based on your organization, and you're not satisfied with the court ruling, can you now appeal to? You can appeal to the regular.
For instance, in this one, say, when the board, the NSITF board, management board, decides a matter, you are not satisfied, you have a right of appeal to the board. Oh, maybe the compensation you have been paid is not adequate, or it's not commensurate, or it's not in accordance with the provision of the Act. You make an application appealing to the board that this thing you have given unto me is not adequate, or is grossly inadequate, or not in line with the provision of the Act.
Okay.
Now, the board will give a decision. Now, the verdict of that board is subject to litigation in National Industrial Courts. So, if maybe your compensation is not adequate or miscalculation in whatever they are doing, then the next step you take after the verdict of the board is to proceed to National Industrial Court and channel your grievances there. And if the National Industrial Court gives a decision and you are not satisfied, you still go to the Court of Appeal. And where the Court of Appeal again decide on such a matter, you still have the Supreme Court to go. So it's procedural.
Okay.
It's procedural that way.
Okay, so let's open up the phone line 081-8999-1011. You can call in if you have further questions, and if you want to make any other contribution in this regard, then that's the number to call. Hello.
Hello.
Good morning.
Good morning, ma.
Welcome. What's your name? Wow, I cannot hear you. There seems to be some noise. I think you need to call back. Maybe you need to move away from where you are.
Okay.
081-8999-1011. That's the number to call. It's Probono Chambers on Human Rights Radio 101.1 FM. Hello. Hello.
Hello, good morning, Ruth.
Good morning.
Yeah, good morning, Barrister Adana and Barrister Adams.
Good morning.
Good morning.
Jamil.
Yeah. Well, my question was, well, is it normally stated in the article of association of your company or any other company, something like that? Usually, as in stated in the article of association of your company or any other company, someone is working, is entitled to such compensation. That is my question. Thank you.
All right. Thank you.
Thank you very much. It's not. You don't need to state it in the memorandum or article of association. You don't need to, it's a law. The law has provided for it. That's why it's called Employees Compensation Act. So you go through the provisions of the Act. It will guide you on what to do. So it is not. You don't need to state it there. Again, there are many employment that are not even in writing. So you can employ somebody orally or in writing. So if you employ somebody orally, you may not state all this may not be discussed. But whether it is discussed or it's not discussed, it's a statutory provision which you must comply with.
Yeah. Okay. I'm sure that answers your question. If it did not, then you may have to call back, Jamil. 081-8999-1011. Hello.
Hello.
Good morning. Hello. Okay. Can you hear me? All right, I'm not sure this person could hear me. If you can, why don't you call back? 081-8999-1011. Hello?
Hello, good morning.
Good morning.
My name is Henry.
Your name is?
Henry.
Okay, Henry.
Yeah.
Welcome.
You work with someone and time to pay you. You ask for your salary, and the person said, you people bargain to be paid a certain amount, and time for them to pay you, they now short the money and pay you quarter of the money. And when you ask, they now said it's assault and insult. And before you know,
it's what?
They call the nearby police to come and carry the people to the station. All went to the station, we were detained, and we were granted bail. After 2 days, they called us from our home to come and explain. So we explained to the DPO. He said he's going to speak to the person that employed us. They went back home. They called us the next 2 days to come back. So when we come back, the man said they delay us to around 4 to 4:30. They said they moved the matter to court. When we went to the court, a bill that the prosecutor said we cannot be granted bail, of which the lawyer we brought said these people have been granted bail for the police station and they were coming from their home. They now give us a bill that is very hard. Said we should come with level 8 and 60,000. So before we rally around to get a level 8 to short us out, they've already put us in Black Maria. We went to the prison. In the prison, they now went to after staying for the prison for about a week, they now granted us a bill. We would then keep a date for the court hearing. The first hearing, they did not come. Nobody appeared in the court. The IPO of the case did not appear in the court. The principal in the matter did not appear in the court. They adjourned the case. Second hearing, they did not appear in the court. Third hearing, the prosecutor said the prosecutor should speak. Fourth hearing, the prosecutor came back and said she's not aware that she has a matter in the court. So they now fixed a date for the final hearing for them to come with their evidences that these people committed the crime. People said that they committed. Then the final hearing, we went to the court. It was just 19th of February. We went there. They did not come with any evidence. Nobody appeared in it. The judge now ripped up the case. Now, in this issue now, for accuse us as because they say it's a criminal charge, assault and insult, of which we didn't try to commit such a thing. So what will now be our own step now of this matter? Because since they will not be working, and the lawyer said, let this embargo remove from these people's neck these criminal charges before they now remove they now come out the matter in the court. Now these people that take us to court, what will now be our own? Because our money is still kind that they have not still paid us. That's why I called to ask for a direction.
Okay.
Okay. Let me start this way. Every laborer is what his wages.
Yes.
Is what his wage. Is entitled to his wages. Now, when your employer refuses to pay, now as an employee, you have to approach the matter civilly.
Okay.
It is possible, I was not there. It is possible that you were violent in your request, or you violated the person of your employer. Otherwise, nobody could have cited you for assault. So if you want to be sincere to yourself, you must have done something very grave to that person, and there is overwhelming evidence. That is for the court, for the prosecutor to prove. Now, if eventually that case goes through the normal trial, and you are discharged and acquitted, then you have a right to go to court to proceed against your employer in the court of law on malicious prosecution. That's a different ballgame. But as per your salary, you have worked for it, you are entitled to it. Again, are you on suspension now, or has your employment been terminated, whether in writing or verbally? That's another. It's terminated.
Yes.
Oh, he has given a letter of termination.
But they did not give any letter.
Okay.
Okay.
Because this environment, like environment as if you working in villa, and the environment you work in, villa that has 3 gates, has police, has everything. Even though they tell you, you don't even need to talk. The environment that you be so intimidated that you can't even talk, tell to your colleagues hi. Is that environment that me personally will go and intimidate somebody who feeds you for 2. I'm a chef. I feed you for 2 weeks.
Okay.
Continental dishes.
Okay. Since you have engaged the service of a lawyer, I'm sure your lawyer will do justice to that. But I've just told you, you are entitled to your salary, then all the steps to be taken. And I'm sure your lawyer will do the necessary things.
Okay.
Thank you.
All right.
Thank you.
Thank you for calling.
Thank you.
All right. Okay, we have room for another call. 08189991011. Pro Bono Chambers. If you have any questions for the lawyers, you can call in. Hello?
Hello?
Please turn off your radio.
Hello? Yeah, I'm Ibe. I'm calling from Abuja.
Okay, Ibe.
Yes, sustained an injury in 2004 in active service. We had an accident when we were on a project. Although I did not prepare for compensation from my ministry because I did not know of all this. We are ignorant of the system. But I reported the incident officially. What do we do now? Is it too late to request for my compensation? I had a fracture then. I was admitted at specialist hospital, Gogolada.
2004, it happened, you said?
Yeah, 2004, November. I applied for all this insurance because I'm a civil servant. We didn't know those things. We are going to cite our vehicles from assaulted, and as we are going, and most of us, even one person died, but I sustained a fracture. I was speaking. I didn't request any compensation. What do we do at this time?
Well, it's very unfortunate. We have just we told you that all actions must be brought within 1 year. Otherwise, it will be statute bar. I'm afraid your action must have been statute barred. Ordinarily, because the new law is clear on what the compensations are. The quantum of compensation, for instance. But if you had applied earlier, for instance, for fatal accident leading to death, a widow or widower who depends wholly on their spouse with 2 or more children gets about 90% of the deceased employee's remuneration on a monthly basis. Now, if you are a widow or a widower with a child, you get about 85% monthly. And if you are a 50-year-old or above spouse without a child or an invalid spouse, you receive about 60%. So you have your compensation is between 30% to 90%. But it must be done within time. So if it is not done within 1 year, I am sorry, you have lost it. You have lost it. And you remember that ignorance of law is no excuse. You ought to have sought counsel. It is too late in the day.
Let me start thinking at this point before I bring up something that happened 20 years ago. All right, let's see if we can squeeze in this call. Hello?
Hello?
Yes, good morning. You're welcome.
Good morning. My name is Desmond, calling from Gudu.
Okay, Desmond, we're listening.
Yes, I want to know, I have an issue with somebody, a person who duped my brother. Then, although we like to bracket it, but when my brother was coming to be bracketed, the pressure was but I have to look for another alternative to arrest this person. So, and I can see that the police people, they are not doing their work in the police station. So I want to know, like, if the issue now, because the IPO is telling me that if this issue will go to court, I will not get my money on time. So I want to know if there is any timeline is to take that kind of issue to court.
Okay.
Okay. In crime, time does not run against the state. It's a timeless matter. Okay. But again, you have two rights of action. One is civil, one is criminal. The police, even though the police go on with their criminal trial, you can still proceed against that person. If it is a monetary matter, you can still proceed against that person to recover your money in the civil court. All you need is to consult a lawyer.
Oh, okay, sir. Okay, sir.
Thank you very much. Thank you very much.
All right. And that does it for the calls we're picking on Pro Bono Chambers this morning. Do we have anything left out to say still on the issue?
Well, let me just conclude that, like the last caller said, you don't sleep on your right. When anything happens to you, it is better for you to ask questions, particularly those who are knowledgeable in that area. Now, once a matter is started bad, there is nothing you can do. At that stage, you become helpless. The court cannot help you. The law will not help you. Then you cannot help yourself.
Is there a way you can explain this statute by in a very layman way? So that
what I mean by statute bar is the law provides, for instance, the Employees Compensation Act provides for time within which your action is actionable, or what happened to you is actionable. What I mean by this is this: if something happens to you on the 1st of January 2018, the law provides that you must explore all the necessary avenue, take action between 1st of January 2018 to December 31st. While you allow it to spill over to 1st or 2nd of January 2019, the law says no, you cannot do that anymore.
There's nothing they can do again.
You cannot do that anymore.
That's statute bar.
So that is why we as citizens, you must seek counsel. Particularly when the law says that the ignorance of law is no excuse. Okay? Then apart from that, a lot of people are not aware of the provision of this law as to compensation. Some, it will happen to them, they don't even know what to do. So when such things happen, what you do is to write the employer. This is what has happened. Notify the employer of what has occurred. Then it's now the duty of the employer to take your matter to NSTIF, Nigerian Social Insurance Trust Fund. Then those people will take the matter and address it appropriately. And where you are not satisfied, you go further to the next steps we have discussed earlier. Thank you.
Okay. Thank you very much, Barrister Adamson and Barrister Adana, for being with us on Pro Bono Chambers today.
Thank you for having
We will do this tomorrow, God willing. But do stay with us on Human Rights Radio 101.1 FM. I'll be back in the 11 o'clock hour on Media Lab.
Your right, my right, our right. Everybody's right is protected. Human Rights Radio 101.1, redefining broadcasting.